Hi, everyone. We're just waiting a few minutes to let everyone join, and then we'll get started. We're going to wait just a couple more minutes to give everyone a chance to join the meeting. Hello and welcome. Thank you for joining us for today's workshop discussion on complete property and casualty rate application. I am Nikki McKennedy, Attorney 4 at the California Department of Insurance. Next slide, please. I'd like to remind all parties that this meeting is being recorded. Any oral comments, written comments, or presentation materials made will become a matter of public record. Today's discussion is in regard to the contemplated amendments to California Code of Regulations, Title 10, Chapter 5, Subchapter 4.8, Article 3, Section 2643.3, Article 4, Section 2644.27, and Article 8, Sections 2648.1, 2648.2, and 2648.4. The Department of Insurance file number is REG-2019-00025. Ordinarily, the department prefers to hold in-person meetings to increase public participation. But due to unique circumstances during this pandemic, the department is using a virtual format for today's workshop. Today's discussion workshop began at approximately 1:00 p.m. and shall continue until all in attendance wishing to provide comments have commented, or 5:00 p.m., whichever is earlier. Next slide, please. This rulemaking is exempt from the Administrative Procedure Act, Government Code Section 11340.9, Subdivision G. However, we want to continue in the rulemaking tradition of holding a pre-notice workshop to get preliminary input on the draft. The proposed regulation text was included in the department's February 23rd mailing, and copies may be downloaded from the department's website. Please email cdiregulations@insurance.ca.gov now if you need a copy of the proposed regulation text. If you are attending this virtual meeting and would like to be notified of activity related to this matter, please provide your name and the name of any organization you represent via electronic mail to cdiregulations@insurance.ca.gov. You may also refer to the department's February 23rd invitation for this email address. Please note, if you received an invitation to this workshop discussion directly from the department, you are already on the relevant mailing list. Next slide, please. Any interested person may participate in today's discussion. Please use the chat function to indicate that you would like to speak. Please be advised that participation in this workshop discussion is in addition to, and not in substitution for, participation in the formal rulemaking process. Any comments, oral or written, received in connection with today's workshop discussion will not be included in the rulemaking file, but they are helpful as we continue to update and refine the text. The department is not required to respond to comments received before any future notice of proposed action. For this reason, if you wish to have comments included in the rulemaking file or be included in the response to comments during the rulemaking process, you must present your comments during the formal public comment period. These procedures will be outlined in any notice of proposed action that is issued in the future. Should you wish to submit written comments, we ask that you please submit them via electronic mail to nikkimckennedy@insurance.ca.gov. That's nikki.mckennedy@insurance.ca.gov by the end of the day today, April 6, 2021. During the participant comments part of this virtual meeting, in between speakers, we will announce the next speaker verbally and indicate who is up next visually. When it is your turn to speak, we will shift you from being an attendee to being a panelist. Please remember to unmute yourself, and if you wish to, turn on your video. When you speak, we ask that you begin by stating your name and identifying the organization that you represent. Again, thank you for joining us today. The proposed regulations concern contemplated amendments to regulations that specify the materials and information that must be included initially in a complete rate filing application submitted to Insurance Commissioner Ricardo Lara under Proposition 103. Next slide, please. We will now hear from those who wish to provide comments. Please note that although we have not set a time limit on public comments, the length of permitted comments may be impacted by the number of persons who wish to speak. We encourage all participants to submit comments in writing to ensure you are able to convey all of the points you want the department to consider with regard to this proposed rule. Next slide, please. Please remember, if you would like to share any comments, use the chat function to indicate that you would like to speak. So Pamela Presley. Ms. Presley, are you present on the webinar?
I'm here. I'm just trying to start the video.
It's up to you if you want to turn on your video.
Yeah, it's just taking a while, but I am. Can you hear me okay?
We can hear you.
Okay, I think my internet is just a little bit laggy, so bear with me if it cuts out a little bit, but you can hear me fine?
I can hear you great. I assume everyone can hear as well as I can, so I can hear you really well.
Okay. Thank you, Nikki. And thanks everyone at the department for holding this proceeding today. My name is Pamela Presley. I'm a senior staff attorney with Consumer Watchdog, and I've been litigating Prop 103 matters before the department and in the courts for over 20 years. We really appreciate you opening this workshop, and we support the commissioner's cleanup of some of the regulations that specify what is needed in a complete rate application. As you know, Prop 103 requires that insurance companies open their books and justify their applications for rate changes before they go into effect, so that no rate shall be approved which is excessive, inadequate, unfairly discriminatory, or otherwise in violation of Prop 103. And of course, the insurance companies have the burden of proving that their requested rate changes meet the requirements of Prop 103. As you also know, that a big part of the framework is that public participation is encouraged. Consumers can initiate and participate in these proceedings and request hearings on rate applications. And then Section 186107 requires that all the information that's provided to the commissioner pursuant to Prop 103 has to be made available for public inspection. So obviously, in order for the commissioner to review rate applications effectively, he and the public need companies to submit all underwriting rules, rating rules, eligibility guidelines, systems, manuals, we believe models as well, algorithms that are used to determine whether a company is going to sell insurance to a person and how much that person will pay. And that was confirmed in an August 2018 general counsel letter from the department that said that, because underwriting rules determine the type of risk to be insured and the coverages to be offered, underwriting rules must be analyzed in connection with the rate review process. And that same letter said that a complete copy of the underwriting guidelines must be submitted with all rate filings, regardless of the line of business, whether or not a change to those guidelines is being proposed. So as you also are aware, and the companies are aware, the rate filing instructions that are available on the department's website also reflect this reality that underwriting guidelines must be submitted with rate applications. But even though the department's current rate application forms, exhibits, and the instructions clearly provide what must be submitted with a rate application, they don't have the force of law, and they can be updated occasionally. Some of those provisions in the rate filing instructions don't always comport with what the law says. And that's why it's really necessary to update the regulations. Right now, Section 2648.4 of the regulations has an outdated provision that refers to the 1996 rate application form and exhibits and filing instructions. So that's a primary reason why we need to update the regulation. As you're also aware, a lot of times in rate proceedings, there can be lengthy battles between consumer groups and the department and companies over what needs to be filed, what needs to be made public. And we believe with a clear regulation, we can eliminate a lot of that, back and forth that consumes a lot of time. And, companies often complain that the rate filing process takes too long. But at the same time, they will withhold information, and, we have to get into this back and forth. So I think it's really important that the regulations clearly spell out what must be filed, and that everything that is filed, of course, is subject to Prop 103's public disclosure requirement. Now, we're going to be submitting some really detailed comments on each provision of the regulation, and there's some changes that we're proposing. Some of them are just clarification, but I did want to walk through just a couple of points on the very specific big picture things that we think should be included, especially in 2648.4, the complete rate application regulation. So I'm going to just focus on that right now. Obviously, we support the amendment to that section to eliminate the outdated form, application, exhibits, and filing instructions, and to make clear that a complete rate application must be, we actually recommend, in addition to what the department has proposed, that a complete rate application must be filed when an insurer seeks to change any rating, rule, or underwriting guideline or eligibility guideline. And that's because Section 186105 of Prop 103 applies not only to rate change applications, but it also prohibits rates from remaining in effect that are excessive, inadequate, and unfairly discriminatory or otherwise violate Prop 103. And as I talked about, underwriting guidelines are used to determine eligibility and rating, so they're linked to the rates, and the department has confirmed that in its legal opinion letter. So one of our proposed amendments is that you make clear that with any change that's made to one of these guidelines or rules or other criteria, that a complete rate application must be filed. We also have a recommendation that you add models that are used for determining rates, premiums, and eligibility to section 2648.4. Insurers often claim that the documentation relating to catastrophe models for earthquake line and fire following earthquake exposure and other lines, and then other models they might use to determine premiums for homeowners insurance, they often say those are proprietary or confidential. So we would propose that you also include models, and that would allow the department and the public to more closely evaluate how those impact rates and comply with Prop 103. And then finally, we would just reiterate that anything that's filed with the department obviously has to be made publicly available. There's a place that we have proposed adding some language to that effect to the regulation, and that none of the documents that are submitted can be marked confidential, because that's another thing that often happens is documents may be marked confidential and then they're not always submitted in the publicly available filing. And I'm going to stop there. I may have some further comments after others speak, but we will, as I said, be submitting detailed written comments, and we'll submit those later this afternoon. Thank you.
Thank you, Pam. If anyone else would like to speak, please use the chat function to indicate that you are wanting to make some comments. It looks like, okay, there we go. Mr. Fraser, go ahead when you're ready.
Hi there, is the audio and video working?
We can hear you and I can see you.
Okay, thank you. My name is Rex Frazier. I'm president of the Personal Insurance Federation of California. We represent large property casualty insurance companies focused on personal lines, so the much more heavily regulated portion of the rate regulation world. We certainly are glad that the department is taking a look at the rate review process, because it's been a long time coming that we have an opportunity to really publicly talk about how to find the right balance between Prop 103's rate regulation and a business-like process where companies are able to robustly compete. The workshop draft does cause us considerable pause. We'll submit a fairly lengthy set of written comments by close of business today, but I just wanted to outline a few thoughts for your consideration until you wade through the detailed comments. For the complete rate application concept, we would urge the Department of Insurance to get more clear, not less. Certainly, this proposal adds significant more confusion than certainty about what the rate review process should entail. Instead of having a concrete and practical checklist of requirements that all involved would agree constitute a complete rate application, the proposal goes quite a bit in the opposite direction. Just one example is in 2648.4. In the definition of a complete rate application, the proposed language actually says the complete rate application includes without limitation any and all of the following. And so how can this be a definition of a complete rate application where it's explicitly saying it's actually not a definition of a complete rate application? It's the things that are listed plus anything else that a rate analyst would require an insurance company to submit. And so that can't possibly be the definition of a complete rate application. That's just simply saying it's these things and whatever else an analyst wants at any time. And so that simply is the opposite direction of where we need to go. Moreover, a process that requires all the elements in the definition of a complete rate application to have a linkage to the CDI's prior approval template is a must. It's hard for us to understand how we can have a prior approval regime with very specific elements of all those things that constitute the components of a proposed rate level. And then we have other information that's not even referenced in the CDI's regulations or the template. The template requirements should be tied closely to the definition of a complete rate application, and the definition of a complete rate application should not be open-ended as the current proposal is. Second point is sort of a corollary, is to the extent that there is really this sort of new catch-all laundry list sort of approach that defies real understanding of its extent. There are some elements of the proposal that are well beyond the department's authority to require. The Department of Insurance, certainly has grand power under 1861.05. That's not disputed, but the department has in the past unsuccessfully several times attempted to regulate underwriting in a way that simply is not permitted by Prop 103. This is not a new issue, and certainly dating back to 2003 when we last litigated the issue with the Department of Insurance, the Department of Insurance continues to insist it has power that's not outlined in Prop 103. And to the extent that this new definition of a complete rate application gets to things that are wholly as to eligibility without any rate impact, that's simply not within the department's prior approval authority. It's not appropriate to be in this definition. Meanwhile, we would hope that as the department is considering looking at the rate review process, that the department take the opportunity to fix known and understandable sources of delay that are in the current process that reduce both admitted market availability and price competition that could otherwise ensue, and take this moment to really take a closer look at the objection letter process, the way that the rate filing process or rate review process works today. There are no clear standards for when the department will issue an objection letter, how many that they can issue, the subject matters that they can address, particularly, which is oftentimes the case, delay related to things that aren't even part of the rate calculation somehow get put into an objection letter, and then that the process of back and forth between a company and an analyst can go on for months when there's no dispute as to what the appropriate rate level should be and is justified. And so as a result of a process that needs improvement, the objection letter process, certainly this is also an opportunity to talk about how the current system really fails to address excessive CDI reliance on insurance companies waiving the rights they have to a timely review that are guaranteed by Proposition 103. Certainly for large companies in personal lines, the notion of getting a 6-month approval, which is contemplated by Prop 103, that's very unlikely at this point. And instead of fixing the system, the department typically will tell an insurance company if they want to avoid a hearing, then they better waive their rights to a review within 6 months. And that's simply not not an appropriate approach for the rate review process. There should be no reason why filings should take as long as they currently take. And I would hope we would spend our time tightening down the precise definition of what a complete rate application is and the types of questions that can quickly be resolved in the back and forth between the companies and the rate analysts, and if there's an intervener, the interveners, and ultimately get to a point where the CDI would rarely rely upon a waiver of deemer rights rather than routinely. And then just lastly, a procedural matter, if and when the department proceeds with a formal rulemaking, we would urge the Department of Insurance to treat this as a rulemaking that is subject to the Office of Administrative Law Review. While there are certainly precedents for saying that a regulation dealing with the setting of prices, rates, prices, and tariffs is exempt from OAL review. What's not exempt from OAL review are non-rate matters that are grafted on to a rate-making regulation, which is certainly the case in this proposal. There are several items in this proposal that are not subject to prior approval, are not appropriate for a rate-making exemption proceeding, and the department simply cannot graft those things that are not subject to prior approval onto a rate-making rule and then claim the rate-making exemption or the exempt rulemaking procedure. So we would hope that if you do proceed, ultimately this is something that you would submit to the Office of Administrative Law and be subject to both the standards for clarity and authority, both of which in this current draft, we certainly question whether there's sufficient clarity to put the regulated community on notice as to what the expectations actually are for its filings, and certainly do not agree that the claimed authority in the proposal is actually consistent with law. So we'll certainly by the end of the day submit our comments and appreciate the chance to outline our views verbally as well. Thank you.
Thank you, Mr. Frazier. Next to speak will be Lisa Brown. Ms. Brown, can you hear me? Ms. Brown, are you present?
I am. Sorry, I somehow, as soon as you called out my name, was disconnected from you.
Oh.
But yes, I have rejoined. Thank you. My name is Lisa Brown. I'm with the American Property Casualty Insurance Association. And as with the previous speakers, I thank you for holding this workshop today. I'd like to say that we also will be submitting written comments by the end of the day. And first want to say that APCIA certainly shares all of Mr. Frazier's concerns. So I will absolutely try not to repeat the points that he made. Except perhaps with this one. APCIA does believe that CDI is in this draft applying an overly broad reading of the commissioner's authority. The proposal includes requirements to file material that go well beyond the granted authority to regulate rates and clearly intrudes into requiring material to be filed that goes into underwriting practices unrelated to rate. And to date, as far as we have been able to glean, neither the legislature nor the voters have granted CDI that authority. With regard to the draft itself, we have some concerns that in 2648.4E that there appears to be a question as to whether this would apply retroactively to rates that have previously been filed and approved. We would certainly take the position that it's unreasonable, unnecessary, and inefficient to never bring the rate filing to a conclusion on the basis that you may want to seek additional information in the future. So we would oppose any application of changes should you go forward to be effective retroactively. Similarly, we share the concerns that have been expressed about perhaps a lack of clarity in terminology used throughout the proposal. In our written comments, we'll certainly provide specific examples, but it seems that there is some overly broad and vague language that, as previously mentioned, actually provides very little guidance to insurers and would certainly result in a less efficient and slower rate filing process. In one thing that we as the representative of about 60% of the commercial market in California, APCIA strongly believes that commercial lines should be exempt from these extensive filing requirements. In general, you're dealing with sophisticated policyholders, more complex risk with a reduced risk of harm and heterogeneous risk. Further, a lot of large commercial policyholders typically utilize a broker in obtaining coverage and tend to acquire more individualized coverage than would be indicated in many of the materials required to be filed. And again, we will be submitting written comments, but I would just like to close by saying that I think today's insurance marketplace demands an increasingly nimble industry capable of responding to evolving coverage needs and emerging technologies. And it seems in the draft that's been shared that the onerous filing requirements would undoubtedly stifle innovation and actually hinder insurability to respond to policyholder needs. And thank you again for the opportunity to speak.
Thank you, Ms. Brown. So I don't see any panelists in queue right now. Please remember, if you would like to speak, go ahead and use the chat function to indicate that, here we go. I think someone is coming. But in the meantime, if someone is speaking, you can go ahead and use the chat function to say that you would like to speak and be put kind of into line for speaking, if that makes sense. So now we're going to hear from Steve Clark. We'll give him a minute to get connected.
Can you hear me?
We can hear you, Mr. Clark. Go ahead.
Okay, thank you very much. My name is Steve Clark. I'm Vice President of Government Relations for Verisk, and my comments today are specifically on behalf of Insurance Services Office, as well as AIR worldwide. For over 50 years now, Verisk has developed innovative solutions to measure risk, including advanced tools and analytics to support a healthy insurance marketplace. We are concerned that the broad scope of the proposal could result in a cascade of unintended consequences that may ultimately have a negative impact on California consumers and the state's insurance marketplace. Let me explain. So we strive to improve our innovative solutions to help insurers understand the risk they assume with a focus on cost-based pricing. This allows carriers to approach the market with the confidence that business assumed is priced commensurate with the exposure being placed on their books. These tools encompass a broad array of offerings, from advisory prospective loss costs to models covering catastrophe exposures, and applied to a broad spectrum of market players, including primary admitted carriers through to the reinsurance market itself. The proposed amendment suggests that a complete rate application must include any and all criteria, guidelines, systems, manuals, and algorithms the insurer uses to determine whether to accept, examine, inspect, cancel, non-renew, or re-underwrite a risk, or modify an applicant's or insured's coverage or coverage options without limitation. We are concerned that such a broad stroke may sweep in many of the advanced tools and models we produce to support a healthy marketplace. Verisk invests a significant amount of time and expense in terms of both human and financial capital in the intellectual property that powers these tools. Understandably, we need assurance that our intellectual property and related trade secrets are not exposed to our competitors, not only in California, not only in the United States, but also globally, for it to make business sense to continue investing, developing, and refining our work. In all other states, such protections are recognized and procedures are in place to protect this investment and encourage innovation. We note that California Insurance Code, um, specifically 6254 sub K, um, affords both copyright information and trade secret information protection, which has also been recognized by the California Attorney General opinions that have indicated that both the state and state officials are subject to copyright laws. And there are no prior California court decisions that would appear to unambiguously support such a broad availability of such information. We also find that our concern is that the current rate filing processes and the broad sweep of the proposal could do just that, expose our information. This could have a chilling effect on innovation in the state if the value and importance of the underlying information is not recognized. The draft regulations need to take a more narrowly tailored and balanced approach to this information. Moreover, many insurers have utilized innovative tools and models to better understand risk for decades. Sophisticated models continue to improve and are a dramatic improvement over historical methods for determining risk. Innovation can help foster increased competition in the insurance marketplace, which is a benefit to the consumers. If insurers are forced to move backwards in the state, away from more accurate and granular risk information, they may need to take a broader and more conservative approach in underwriting, which, in turn, could potentially have the unintended consequence on insurance availability. More consumers could be forced to obtain insurance from the non-admitted market, and adverse selection could result due to the non-admitted markets still having access to innovative tools and models. In such a scenario, California consumers will have less access to cost-based pricing that more accurately reflects premiums commensurate with the level of their risk, which would continue to be enjoyed by those in the states outside of California. It also seems highly unlikely that insurance consumers would benefit from having direct access to such advanced program information, such as complex codes and algorithms. Rather, that is the job of the California Department of Insurance, to ensure that the tools used in the marketplace result in rates that are not excessive, inadequate, or unfairly discriminatory, and to support a healthy insurance marketplace. Without assurance that proprietary information will be protected, there will be a chilling effect on the availability of innovative tools and models to support a healthy insurance market within the state of California. I appreciate the opportunity to provide you with comments today, and we will be submitting our comments in writing. Thank you very much.
Thank you, Mr. Clark. Is there anyone else who would like to speak? Again, please use the chat function. We just want to give everyone a chance to speak up if they want to speak, but we're just going to give it a moment more. So it looks like we have no new speakers at this time in queue. It looks like Ms. Pamela Presley would like a chance to respond to some of the prior comments. So we're going to go ahead and call on Ms. Presley again. Ms. Presley, when you're ready.
Thank you, Nikki. Yeah, I just wanted to make a couple of points in response to some of the comments. I think in response to Mr. Fraser, he mentioned that the regulation should refer to the current rate application forms and templates. And we actually agree with that, and we make a recommendation to that effect. And as we know, the current rate filing instructions do require the filing of rate manuals and underwriting guidelines. And so for some of the commenters to say that this regulation is going beyond the commissioner's authority, clearly the commissioner does have authority to review rules and guidelines, and this regulation is specifying, different names that insurers might refer to these things as algorithms or rating criteria or guidelines. It's being, rather than it being in the rate filing instructions, it's being clearly spelled out in a regulation, because insurers have said that the rate filing instructions don't have the force of law. So, they don't want to follow the rate filing instructions in some cases, so we need to put it in the regulation. Other companies have had no problems following the rate filing instructions, and they do submit the required information. Clearly, the commissioner has the authority under 1861.05B to require a complete rate application and such other information as he may require. The fact is that underwriting criteria, including decisions to cancel, non-renew, or to determine eligibility, do indeed have an impact on the insurance company's overall risk. That's one way that they can limit risk, by limiting the people they insure. And so we need to see what impact that's going to have on the overall rate and individual rates. So the commissioner has the clear authority to require these things. It needs to be spelled out in the regulation. And lastly, I just wanted to say that there's nothing in Prop 103 that says you can outsource any of this information or determination on the part of the insurance company, which has the burden of justifying the rate under Prop 103. So if they want to do that, those third parties that are providing these models or criteria also need to be aware that in California, it is the law that that information has to be submitted as part of a rate application in California, and it has to be made available to the public. Otherwise, you're circumventing the very provisions of Prop 103 that are intended to allow the public to participate in the process. We don't just allow companies to submit something and not explain how it's done. And that's the whole purpose behind these regulations, to provide clarity and transparency. And so we support the provisions. As I've said, we've made some specific recommendations to refer to the current rate application, because those have the exhibits referenced, and we can incorporate that. But other amendments that we've made are just to make the regulation even stronger and clearer. And we appreciate your time.
Thanks, Pam. I think next up, we're going to hear from Rex Frazier again. When Mr. Frazier is ready, he can go ahead and start speaking.
Hi there, thanks a lot. I just wanted to respond to Ms. Presley's response with two points. We certainly, if this reg were focused, or this proposal were focused on clarity, we would certainly be all in to help. But that's not what this proposal does. It is simply unknowable what is included within the definition of a complete rate application. If there needs to be modification of the current regulations that make reference to various specific exhibits, that is sensible to us. and that's the way to go. But that's not what the text of this proposal would do. It's quite the opposite. It simply is unknowable what the definition of complete would be under this proposal. So there's no clarity involved here, to pick up on the last part of Ms. Presley's statement. As to underwriting and this view of 1861.05 that it's whatever information the commissioner wants for whatever purposes can just be stuffed into the prior approval regs, that's certainly an overstatement of the law. That's not ever been the law, and courts have never said that is the law. And whether it was the AIA v. Garamendi case or the Smith v. State Farm case before that, courts have had little trouble in distinguishing between the two aspects of underwriting. Underwriting for purposes of eligibility and risk selection versus underwriting which has rate impact. To date, courts have said the latter is subject to prior approval, the former is not. And certainly to the extent that companies now comply with requests for information from the Department of Insurance, they do it because they desire a respectful relationship with their primary regulator, and they have something they're requesting, which is a change to whatever has been approved. They need a change. And so you're not going to sit there as a company and fight back and forth about whether the department has authority to do this or that, because you just want to get your filing done. It's quite another matter to take things that are not properly within the Department of Insurance's prior approval authority, put them into the regulations as an element of a rate application, a supposedly complete one at that, and then all of a sudden be subject to the department's expansive view of the impact of 1861.07, where everything all of a sudden could be exposed, including trade secreted matters, and that there's no way to do anything under an agreement of confidentiality. And so what this proposal would do is it would say anything the department wants, whenever it wants it, can be required as part of a rate application, and all will be splayed open to the public. And that's just simply not a business-like solution for anyone. It's certainly not going to do anything to speed up rate approvals, and it's certainly not going to do anything to foster more competition. It will simply lead to more conflict that's unnecessary, completely predictable, and utterly avoidable. And so it's unclear to us why we'd want to take a system that already suffers from significant issues where a company can't even predict in advance what its treatment is going to be, what result they're going to get at the end of this. We should be trying to have a system that leads to more certainty, so that companies will find it easier to approach the department to understand if they do this, they'll get a certain result. And this proposal takes us utterly in the opposite direction. And I can't see why the department would want to embark on something that's going to be so controversial and has a history of breeding litigation. It doesn't seem like this is the direction that we should go now. But thank you very much.
Thank you, Mr. Frazier. Again, is there anyone who has anything that they would like to say at this time? So at this point, it appears that no one else is requesting to speak. So we would like to thank you all for attending today's public discussion workshop. And in particular, thank you to those who participated today by providing comments on the proposed regulation. Should you wish to submit written comments, We ask that you please submit them via electronic mail to Nikki McKennedy at insurance.ca.gov. That's NIKKI.MCKENNEDY at insurance.ca.gov by the end of the day today, April 6th. And if you would like a copy of the proposed text or to be notified on any further activity on these proposed regulations, please email cdiregulations@insurance.ca.gov. As a reminder, today will not be the only opportunity for public comment. There will be an opportunity for further public comment during the formal rulemaking process. Thank you all.